I would like to run through a few housekeeping matters, which will hopefully enhance this webinar experience for all of you. As participants, you are all automatically muted and the chat functionality has been disabled. So should you have any questions during the webinar, please make use of the Q&A tab at the bottom of your screen. Your questions will then be submitted to me as the facilitator. I will select a few of the questions to discuss with the panel at an appropriate time during the webinar. And please note that we will not be providing written responses to questions. Finally, please note that the webinar is being recorded and a copy will be available later today on our website, www.bowmanslaw.com. Just to introduce our panel for today, I am Xolani Nyali, a partner in the competition practice of Bowman's based in Cape Town, and I'll be the moderator for today's session. I'm joined by Lebohang Mabidikane, who is also a partner in the competition practice of Bowman's based in Johannesburg. We also have on the panel Mr. Kganki Matabane, who is the Chief Executive Officer and an Executive Director of the Black Business Council in South Africa. And then finally, we have Mr. Shawn Flatt, who is the Minister Counselor for Economic Affairs at the United States Embassy. So as you all know, this webinar really was prompted by the fact that on the 1st of June this year, the Competition Commission issued a press release in which it had indicated that it has prohibited a merger on the basis that the merger would lead to a substantial or rather significant reduction in the shareholding of historically disadvantaged persons in the target firm from more than 68% to 0. The facts of the case and the merger in question are now quite notorious and involved Grand Parade Investments, an empowerment entity listed on the JSE, which wanted to restructure its portfolio and in particular dispose of Burger King, its Burger King franchise, and had entered into a sale agreement with ECP Africa, a US-based Africa-focused private equity fund, to dispose of that interest in Burger King and Grand Foods meat plant, which supplied burger patties to Burger King. As we now all know, Burger King operates more than 90 fast food restaurants across South Africa, while Grand Food just supplies the burger patties to Burger King. It was, of course, accepted that ECP did not and does not have historically disadvantaged persons as shareholders. As such, the sale by Burger King, or rather by GPI to ECP, would reduce the HDI shareholding, which was at that point 68%, and with ECP taking over, that would reduce to 0. In light of the above, the Commission found that the transaction would have a significant negative impact on public interest, and there were no countervailing public interest benefits which could cure this concern. As this was an intermediate merger, the Commission was the primary decision maker and prohibited the merger. Now, this was the first time in over 20 years of competition law enforcement where that the Commission prohibited a merger.
Why is this thing? Oh!
On the basis of the merger being found to result in adverse public interest outcomes. In the ordinary course, such concerns have been remedied by parties in the Commission reaching agreement on appropriate commitments. Of course, this now seems to have occurred by way of a consideration application before the Competition Tribunal, which Lebo will speak to later. And the parties have sort of sweetened the previous commitments which were offered to the Commission, although we should state that, of course, from the Commission's perspective, their position was that they had not rejected those commitments before, merely that they arrived too late for it to consider them. So there's a number of questions, of course, that decision and the current application before the tribunal that it raises. And in particular, whether this sets a precedent and will be the approach that will be adopted for future transactions, or are we likely to see more prohibitions on this basis? So the panel really then focuses on that and what the future participation will be, in particular of HDIs, in the South African economy, and whether properly construed, the Commission's decision in Burger King sets the standard for assessment of the public interest, or is something less, but even if it's not a precedent, but is a clear indication of a new approach and what we call a business unusual. Just to please remind you again that if you do have any questions or comments, type them into the Q&A button at the bottom of your screen. We have already received some comments and questions from the audience, which we will get to. So to begin off, Lebo, we say that this is the first time in 20 years that the Commission has prohibited a merger purely on public interest ground. Why is this the case? And please take us through the legislative policy or any other changes that may have changed to allow the Commission to get to where it is now.
Yeah. Thank you, Xolani. Good morning, everybody. So, by way of background, the notion that competition policy ought to be one of the tools used to redress the injustices of the past and the resultant economic inequalities has always been encapsulated in the preamble and the purpose of the Act, of the Competition Act in Section 2. Now, when you look at Section 2, one of the purposes of the Act is that it ought to be used to promote a greater spread of ownership, and in particular, the increase of ownership stakes of historically disadvantaged individuals or persons. And then the Act goes on to define HDIs as people falling into the category of those who suffered unfair discrimination on the basis of race pre-democracy. So when you delve into the legislative framework in more detail, what you find is that prior to the amendment of certain provisions of the Competition Act, and these amendments were in 2019, the Act required the competition authorities, when assessing a merger, to initially determine whether or not the merger is likely to substantially prevent or lessen competition. And if the merger was found to result in a substantial lessening of competition, to then determine whether the merger could be justified on substantial public interest grounds. So you would know that the 5 public interest pillars which the Commission must look at when engaging in this assessment. And these are quickly that the Commission must determine whether, or rather determine the impact of a merger on a particular industrial sector or region, firstly, employment, second, the ability of small and medium businesses or firms controlled or owned by historically disadvantaged persons to effectively enter into, participate in, or expand within the market. That's the third pillar. The fourth one is the merger's impact on the ability of national industries to compete in international markets. And of course, for purposes of this webinar, the merger's impact on the promotion of a greater spread of ownership, in particular, to increase the levels of ownership by historically disadvantaged persons and by workers and firms in the market. So despite the crafting of the Act, there's always been a debate about whether the public interest assessment is secondary to the competition assessment, and whether the Act could be interpreted to mean that in circumstances where the merger was found to be pro-competitive, then the authorities need not embark on an assessment of the impact of the merger on public interest. In other words, if the merger was found to be pro-competitive, then there would be no need to justify it based on public interest grounds. And put differently again, why would you need to justify that which has been found to be pro-competitive, so to speak? So that was always the debate in the background. But notwithstanding this debate, the authorities always took the view that the competition assessment and the public interest assessment were separate, and therefore there was in fact a need to embark on this kind of assessment to determine whether or not the impact of the transaction of public interest, the impact of the transaction on public interest, irrespective of the outcomes of the competition assessment. This approach was subsequently then confirmed in the Walmart Massmart case in 2012, as well as various other cases. And I think that this uncertainty and this debate is part of the reason that we have not seen the Commission prohibiting mergers purely on public interest grounds until now. Fast forward to the amendments in 2019, the Act was amended, and these amendments took effect on the 12th of July in 2019. And in terms of the amendment, the Act has now categorically elevated the public interest assessment, placing it on equal footing with the competition assessment. And more specifically, the Act now directs the Commission to, despite its determination on the competition assessment, also determine whether the merger can or cannot be justified on substantial public interest grounds by assessing the 5 pillars, which I've already mentioned earlier.
Super. Thank you, Lebo. I think you raise, I mean, it's quite important to have that background as we go through and discuss what occurred in Burger King. But before I bring in the other panelists, just one more question. So now we've got these new provisions in the Act. So how should we be approaching them, right? For example, is it sufficient for a transaction to fall on the basis of only one of those factors, or can it be saved, as it were, by a positive outcome in another public interest factor? So you have a balancing act. Is it a cumulative one? Also, given the strict timing set out in the Act for intermediate mergers, should we now, as a matter of practice, introduce sort of a pre-notification element to merger control if we think that public interest issues will arise?
Yeah, I mean, that's a very good question, Xolani. So let's maybe talk about how these matters ought to be approached, right? As a starting point, one needs to look at the case law emanating from the tribunal for guidance in order to arrive at the correct answer. I don't intend to go through the various case law cases in detail, but I just want to extrapolate some of the principles that emanate from these cases. So the first principle is this: the Commission must establish a prima facie case that a transaction is likely to have a negative impact on public interest. Once it has done so, then the onus shifts to the parties to counter this position and/or offer remedies to allay the Commission's concerns. There is also the possibility that the use of the word promote in this provision could see the Commission arguing that in mergers where there is no dilution of black shareholding, in other words, in a public interest neutral type of merger, the Commission could potentially argue that there's still a problem because such a merger does not promote a spread of ownership by historically disadvantaged individuals. Now, this approach, in my view, would be quite arbitrary in that suddenly, just because parties are involved in a merger, then they would suddenly inherit this obligation to make the world a better place, so to speak. And especially in circumstances where there's other legislation aimed at dealing with issues of transformation. But I think that's a separate topic on its own. So looking at the second principle from the case law, the Commission ought to look at the impact the impact of the transaction on public interest must be assessed based on each of the 5 pillars of public interest, but that's not where the test ends, right? So the outcomes of each public interest assessment in terms of each pillar must be weighed cumulatively against each other to determine the cumulative public interest impact of the transaction, with the view to avoid a situation where the conclusion is based solely on the impact of just one of those public interest pillars. For instance, where a transaction will avert job losses, the positive impact of job losses on that transaction must be weighed against any negative impact, which, for instance, may be shown prima facie by the Commission, and it may very well relate to a dilution of black shareholding. And so you would have to look at what the outcome is per pillar and then look at a cumulative outcome. And in order for you to arrive at that cumulative outcome, engage in this balancing exercise to try and see, what weights do you apportion which outcome and in relation to which pillar. Obviously, the tricky part here is that the appropriate weight to be afforded to each provision depends on the facts of each case and the extent to which the public interest concerns arise. And it's not clear from the case law exactly what the amount of weight that must be attributed to each of these pillars. But that said, the tribunal has at least either expressly or implicitly given guidance on what it would consider to be an inappropriate outcome of this balancing exercise. For instance, if you look at the Shell TEPCO case from the tribunal in that case makes specific reference to the fact that where the Commission is dealing with a dilution of Black shareholding, or an adverse impact on the participation, or rather on the ownership by historically disadvantaged individuals. Yes, this case did precede the amendments, but the principle is very much the same, right? Where the Commission would have maybe said that they've established a prima facie case that there would be an adverse impact on this participation of HDIs. So what the tribunal said in the Shell TIPCO case is that when addressing such concerns, the Commission, in imposing any remedies or conditions on the merging parties with the view to address these concerns, should never overhaul, should never impose conditions that would otherwise overhaul the entire structure of the transaction in a manner that the parties themselves never conceptualize the transaction. And that effectively the Commission cannot tell parties who to sell their shareholding to or who to transact with, for that matter. And as recently as 2015 in the Nokia Alcatel case, the tribunal, I think, in my view, took the issues a bit further. And the facts in the Alcatel case were a little bit more similar to the Burger King case. And without delving into the specific facts of the case, what was the issue there was that there was some sort of exit of shareholders, but the transaction was in fact a share exchange transaction. And so, because I don't want to delve into the details of that case, I'll just make an example which covers the principle that actually emanated from this case. So if, for example, it's established that a transaction will result in the exit of a Black shareholder who held about 25% in the target, the Commission would then seek to approve the transaction on condition that the same 25% that is lost as a result of the transaction is replaced like for like at implementation of the transaction. Now, one can imagine that this type of condition, if this type of condition is not attainable in the circumstances, the next best thing for a regulator is to prohibit a transaction, right? To prohibit the transaction. But nonetheless, the tribunal in this Nokia case rejected this approach and introduced the concept of value, which in my mind hints at a subjective view of whether the transaction is in fact valuable in the seller's eyes, for instance, notwithstanding the diminution of BE shareholding in terms of the numbers. And the concept in my mind, the concept of value in my mind, is very closely linked to the issue of substantiality. In other words, the Commission would have to consider whether the diminution of Black shareholding is substantial in the circumstances. And obviously the substantiality aspect would fit squarely within the determination around whether or not the remedy imposed has to be a like-for-like remedy, which deals with the exact number of the Black shareholding lost as a result of the transaction. But really, in conclusion, in the Nokia case, the tribunal concluded that instead of trying to replace the exact lost percentage of Black shareholding, it imposed a condition which required that the transaction not be implemented in a manner that results in a loss of value for the BE shareholders. So the tribunal certainly seems to have rejected the notion that if there's an exit of 10%, there should be a replacement by another 10%. So the tribunal's approach in the Nokia matter, in my view, suggests that shareholders, Black shareholders, or merging parties on both sides have the opportunity to convince the authorities that they see some other overall commercial value in the transaction, and or depending on the specific facts, especially with share exchange transactions, that the loss of, for example, 25% of shareholding in Black shareholders' hands in the seller's business does not automatically translate to a loss of value, even if the shares subsequently acquired by the Black shareholders in the acquiring group are less than that 25% that could have been lost as a result of the transaction.
No, thank you, Lebo. So basically, there's a lot more nuance and room to maneuver, which perhaps may not, and because it was an intermediate merger, and we don't have the benefit of the full decision of the Commission, that may have been lost in translation.
Indeed.
And hopefully that comes out before the tribunal. So we've heard the lawyers. They say, well, there's room to maneuver here. It's not all, Rome is not burning. So what's the feeling of Black business on how these public interest factors should be assessed and or approached? And if you just could also in your response include whether you think whether should selling black shareholders have a say in the commission's assessment? As the seller, I'm an HDI shareholder and I want to sell my shares. The commission is going to have a say, but I won't have a say as the seller. Should I be included?
Thank you very much, Xolani, and thank you very much, Bowman, for the invitation. I think I need to start with the context of the country. I think we all know, but I think it's important that to remind people all the time that we were dealing with the South Africa that is dealing with the history of exclusion, and this was done by law. We were trying to empower the majority in South Africa, unlike in the West, where they are trying to empower the minority. We're 27 years into democracy, and black people have got nothing to show for that, for their patience. Black people own less than 10% of the economy, and I must emphasize that this is in their own country, which is an anomaly. If you go all over the world, the citizens will own the majority of the economy, which on its own is unsustainable, and we cannot keep on excluding the majority in the participation of their own economy, and that for us is a threat to democracy. And you have seen, I think all of you and all of us who are here, who are the middle class, we have seen when the looting happens, that you just need a spark to trigger this. And if we continue like this and theorizing and having theoretical discussions, one day the majority will decide that they need to render this country ungovernable, because people are running out of patience. We have introduced the ownership, for example, of a minimum of 25.1%, but most of the companies they are taking that as a maximum, and even in that 27 years, we have not even achieved the 25% minimum, because ideally the ownership of the country should reflect the demographic of the country. So if black people are 90%, the ownership of the country should be 90%, of the country's economy should be 90%. And then we cannot have a situation where people are saying investors are providing jobs, but they're talking about waitresses and waiters as jobs. We need the black people to play a meaningful role in the economy and own the economy. We cannot be limited to being waitresses and waiters. That is not acceptable in the country. It's not sustainable. We really have to change it. And if we don't, we'll be sitting helplessly somehow, somewhere, one day when the people decide to take the things into their own hands. So we support the decision of the Competition Commission. We were one of those people who participated in the amendment of the Act, and we made inputs on the public interest because it's important. Because if you look at the structure for economy, we've got in all the sectors, we've got the big three, big four, or big five who control 90% of the economy, and that on its own is not sustainable because it means the rest of us can only participate in the 10%. So it's important that we support what the Competition Commission is saying, and we support the amended Act that we need to make sure that black people participate. Small businesses need to participate. Black women need to participate in the economy. Youth needs to participate in the economy. People living with disabilities need to participate in the economy without being apologetic and without coming with technicalities and having theoretical discussions. So for us, I think we are going to support the Competition Commission even in the future. We think there must also be a monitoring a mechanism that is introduced, because sometimes these conditions come and get announced in the media. But if you check 5 years from the announcement, nothing has actually happened in terms of the actual implementation. So it's important that these measures like this ones get blocked. The conditions are met upfront, because if you try to say they'll meet this thing in 5 years, you find that nothing has actually happened. And really, as a country, we cannot afford that type of a situation.
Fantastic. So is Black business saying that you would like to see the commission, in fact, sort of look at this Burger King as a precedent going forward and not shy away from blocking transactions if there is going to be a significant reduction in Black shareholding, notwithstanding what other positives may exist, may be put forward? For instance, let's say, as happened in Burger King, which was quite a lot of, more than doubling of the number of employees.
Yeah. If you look at what is called the doubling up of the number of employees, they are talking about the waitresses and waiters. That is neither here nor there. If you look at the top end of the management control, you're going to find these white people there, and white males in particular. So it doesn't necessarily address the issue. It doesn't address the what you call the spirit of transformation. It's basically sugarcoating the actual thing. We know and we see most of the companies, we will have a white people at the top, Blacks at the bottom, and they say no, the company has 80% Black employees. That's not the issue. The issue is that there must be Black people who are controlling, and usually the CEOs and the senior executives, and they get appointed by the shareholders. If the shareholder is white with no interest of having Black people there, they are either going to appoint a totally a white executive, or they're going to choose Blacks that they think are friendly to white interests, who are not going to rock the boat, and appoint them. They're going to appoint other Black people from the continent, because some of them are just here to work. They're not here to effect transformation. So it's important that we really need to implement the spirit of the act. And whether you're a Black company, you are exiting investment or not, you also have the responsibility to make sure that whoever comes in must also advance the spirit of socio-economic transformation. Whether you are Black or white, you are exiting, you really need to have a say and say, I'm getting out, I'm cashing out, but whoever is replacing me must do equally like I did, or even better than me. We cannot go back, because that means we are regressing, and the less than 10% Black ownership that we have will actually even go down. So we really can't afford that as a country.
Okay. And so, and I suppose that takes us very nicely into a segue to open up for, whether should the Commission or the Competition Act and the BBBE Act speak to each other, which overrides which, and how should the two really be approached? In the BBBE Act, for instance, exists what might be called equity equivalent, which of course in the Competition Act, there isn't. It's quite clear that it's looking at numbers of shareholding. So it does seem that even though the BBBE Act is the primary legislation for BBBE in South Africa, that the Competition Act even goes much further. How do you reconcile the two, and how should we try and treat and deal with them?
Yeah, I think we should look at whichever is the weakest and strengthen it, instead of weakening the strong one. So if the Competition Act is stronger, let's make sure that the BE Act is strengthened, because in the Competition Act, it says meaningful Black empowerment is mandatory. So if we think it's not mandatory in the BE Act, let's harmonize the two, but let's not weaken the one that seeks to achieve greater results for the country.
Right. Okay. So, Shawn, turning over to you, sir. So the Commission's decision in Burger King may have caused some concerns in Washington. But I suppose before we deal with that, what's your sense of the US business community's posture towards the overall public interest assessment of mergers in South Africa and really what we're trying to achieve here?
I'd say I would characterize it as one of concern. I think there is a perception that it's not quite clear how the Commission is going to apply the public interest criteria in the future. I mean, let me give you an example. Let's say we have a hedge fund in New York, or let's say a business in Germany. They don't have any current operations in South Africa. They want to enter the market via a merger or an acquisition. I think there's some real questions as to how the criteria would be applied in those situations. I'd like to be clear, there's always going to be a tension, obviously, between businesses' desire for complete certainty and the fact that you need flexibility as a government policymaker. That happens in all regulations. I think the question now is there's concerns as to how it's going to be balanced right now in South Africa. And let me be clear, no one's arguing that there shouldn't be public interest. Right now, as you know, there is a debate in the United States about our version of competition law. We're moving away from the Bork rule, which is basically focused on consumers. And there's the idea that you need to look at all stakeholders and take a much wider view of how competition law is applied. So I guess going forward, the questions are, you know, what business is looking for is more transparency and a clearer idea of what the rules of the game are. So I guess I would say clear guidance from the competition authorities.
Super. And on that point, I mean, the Competition Act, of course, is drafted, as mentioned by Lebo earlier, in positive terms, right? It's the promotion of a greater spread of ownership. So that's it. And here I think the Deputy Commissioner at the Commission has mentioned publicly that, you know, it's not only just a constraint to Black shareholders to sell and realize value for their investment, but this also works the other way around, where such that a selling non-Black shareholder, that when they exit, the Commission still has to have regard to whether there's, you know, that exit will have a positive impact on HDI ownership and workers. So what the uncertainty or sort of guidance would be helpful to foreign investors?
I'd say, as I said, I think there's a need for greater transparency. So it's very clear companies have a duty to do due diligence and to understand the rules of the road, for lack of a better term, in South Africa. But given the fact that we've had so much confusion over the Burger King decision, where you have, you know, very, very sophisticated companies expressing confusion over what exactly the weighting is, whether one criteria has an overwhelming weight or whether there is a way to compensate for problems. The fact that, you know, there are all these questions out here out of Burger King, I think clearly implies that there needs to be greater guidance. So what would that mean? I would think that, number one, the Commission needs to publish decisions as much as possible. If you have a situation where you can't publish a decision because of privacy concerns or some commercial concern, then the idea would be give detailed guidance on the website. So for example, if you look at the Security Exchange Commission in the States, the FTC, the Department of Justice, they have very detailed guidance on their websites. They have guidebooks so that you can go on and have a very clear idea of the criteria, and if there's a weighting, how it gives you a pretty good idea of what that weighting is. If you go on the Commission's website, you know, some of the guidance is from 2015, that's before the amendments. So companies really can't go on there and get a clear idea. You know, we've talked about a lot of questions here today, and I think what would be helpful is if there was clear guidance on some of those questions. So, you know, number one, if there's a weighting of criteria, what is that? Does equity ownership sort of have a far more higher weight than the other criteria, the other public interest criteria? Number two, if for some reason you cannot overcome a negative assessment, for example, the equity criteria, is there a way around it? As you pointed out, if you look at other laws, there is a way to meet or satisfy that criteria in other ways. Is that an option under the law right now? Or can it be made an option? Is there a way to give some sort of clarity as to how to meet a negative assessment? The other one is a point I think that has come up, it was mentioned by the other panelists. I think we need a sort of clarification on the idea of transformation. And by that, as you pointed out, you have transformation as a goal in other legislation, the BBB legislation, and I think there does need to be clarity on the interaction between competition law and BBB law. And then finally, I think there's a need for some clarity on roles. We know in talking to companies and practitioners that companies in the past have gone to DTIC for guidance. And so clarity on the roles between the Commission and DTIC, I think would be helpful.
Super. And I suppose, Shawn, it might be worth a thought to say, well, is there a safe harbor if we're dealing, for instance, with shareholding? You know, if it's diluted by less than 5% or whatever percent, then that's fine. But anything more than that, it needs to be, you know, get a bit more of intense scrutiny, rather than, I suppose, the position we're in at the moment, which seems to be that any dilution may raise issues.
I think there's a number of mechanisms that the Commission can adopt. One would be a safe harbor. I mean, I think what companies are looking for, like I said, is greater clarity and an idea of, okay, what are the rules of the road? Because as I noted before, you know, certainly in our conversations with business associations, companies, there was a great deal of confusion after Burger King about what the rules of the road are, and were there any mechanisms that you could utilize if you felt that there was an issue of you not satisfying an equity requirement.
Sure. Thanks. I think let's turn to some of the questions that have been raised by the participants in the audience. Lebo, I think let's start with you. I mean, some commentators have used the word progressive when describing the Commission's decision in Burger King. Would you be supportive of that description?
Yeah, I mean, Xolani, I think I'm not even sure whether you know, asking about whether the decision is progressive is the right question, right? Because I think we need to be careful, because we need to understand what the law is and the perimeters of the law, what they are, right? And the powers of the Commission. It's one thing to have a progressive decision, but if it's incorrect, then, you know, you have a problem. And obviously, you know, a progressive decision in my mind may be something completely different to what you think, right? So I think let's maybe focus on the law. And I think if you focus on the law, then there's other questions that arise. Firstly, does the decision bring about some unintended consequences? Was the law applied in the way it should have been in Burger King? Does the law reflect the intention of the legislature? And is the law, you know, is the case rather reflective of the legislature's intentions? And is the Burger King case precedent setting, and in such a way that it would withstand scrutiny by the tribunal or the Competition Appeals Court for that matter? I think those are the most important questions to focus on. And I think what I would want to say on that is simply this. it's interesting to hear what Kganki has said, and I think we all agree that there is a need to transform. There is, we have these gaps of ownership in our economy. That's something that I don't think anybody can deny, because the statistics show it, right? But the questions that need to be specifically answered are, for example, does this case, a decision of this nature, have unintended consequences such that Black shareholders are now locked into investments that they would otherwise want to exit? And is that the intention, or what? If the commission says to us that's not the intention, then what's the other alternative, right? Would they want to impose conditions which basically say that once these Black shareholders have exited, then they must invest elsewhere with that money, that the proceeds that they've gotten from the sale of their shares? It's very complex in my view, right? And then you've also got the question around whether this is the legislature's intention. I'm not sure that it is. And the simple reason I say that is that if you look at the posture of the tribunal to these issues, you can already tell that the tribunal has taken, at least in my view, a position that says, the legislature did not intend for one pillar of the public interest pillars to outweigh every other, such that you have a prohibition just based on one. That, in my mind, suggests that even if you've got a dilution of Black shareholding, one should be thinking about whether or not there could be other conditions or remedies imposed based on the other pillars, or even the HDI spirit of ownership pillar. You could have conditions that can save the transaction. And then, the other issue is whether or not, of course, it's precedent setting. We must also remember that this is an intermediate merger, right? Which means that the commission or the final arbiter with the opportunity for the parties to basically appeal to the tribunal in a reconsideration, and that's exactly what has happened here. So, and I don't know if you've seen, recently in the press, that the commission has taken a different approach, following the prohibition, and the commission has actually acknowledged that the assessment has to be a cumulative assessment, which means that you shouldn't, put so much weight on one of the public interest pillars such that you end up with a prohibition. The best case scenario is that you negotiate a condition or negotiate a remedy, and that's exactly where we are with Burger King right now, where the parties have been asked to give a condition on percentage shareholding, which will go to Black shareholders, and they've done that. But along with that, there's other conditions that have been agreed between the commission and the parties. And in my mind, that sort of signals that the commission may very well be considering the fact that, the approach in Burger King may not have been correct. I mean, I know that the commission says that the conditions were offered a little bit late, but because it's an intermediate merger, again, we don't know exactly what the discussions were. We don't know what the process was. So in reality, for me, whether or not the transaction is, the decision was progressive is neither here nor there, because I think that's another very loaded type of approach, and anybody could have, different people could have different answers to that type of question.
Yeah. Okay, so before we move away from you, I think let's just two questions. Now, mindful, of course, that the Burger King decision is still live. It's now before the trial. So what were the I suppose the grounds of appeal, and you may already have dealt with that, and what should clients be aware of, and what should their merger strategies for South Africa include?
Yeah, so maybe talking about the strategies, because I think one could think of a few ideas there. I think, it's become clear to us that one should not take the issue of public interest for granted in our jurisdiction. I think it's been clear for a while, but I think there's been, historically been more, a greater emphasis on employment than any other pillar of the public interest assessment. So clearly one has to think about whether or not there is in fact a negative impact, or what could be perceived as a negative impact on the participation or the spread of ownership by HDIs as a result of your transaction. I don't think we can avoid that. And I hear Shawn saying that, you know, the American market, the international market for that matter, is looking for certainty. I think as legal practitioners, we too would love some certainty, but I think we have to find a way to navigate around these issues in the time being, and for the time being. So I do think that we need to be thinking specifically about what we would want to say to the Commission going into the merger regulation process. Do we want to ask the Commission for a pre-merger notification meeting and start having those engagements potentially in more than one meeting, so that we can sort of find a way to present the transaction to the Commission at a high level and get a sense of where the Commission might go? I would say that's one of the ways we should try and approach these things. But another thing is, we need to find creative ways of dealing with these issues within the perimeters of the law. So I don't think we can afford a situation where, if you know that in your transaction there is going to be some sort of diminution of shareholding, black shareholding in the numbers, I don't think we can afford to go to the Commission and the authorities saying, well, that it is what it is, and we are not ready to have a discussion regarding what we could, what remedies there could be. What we should be ready to do is to debate with the Commission about whether or not there is in fact a true diminution. Because as I said, I don't think diminution is just about the numbers. It's also about the issues of value. So one should be prepared with an argument going to the competition authorities saying, yes, there may be a lesser percentage of shares held by black shareholders post-transaction, but there are other benefits that these shareholders see in the transaction. An example, again, would be in a share exchange transaction where you might want to show the Commission that, you may have been a smaller target firm in South Africa conducting your business here with a majority black shareholding. But when you have a share exchange with an international conglomerate, a listed entity which has got interests in different jurisdictions, that, in my view, is value which the tribunal, again, I think touched on in the Nokia case, because in as much as the tribunal didn't specify what they were talking about when they refer to value, the decision of the tribunal suggests that value cannot just be construed in terms of the numbers only. You have to look a little bit further than what the shareholding percentage is in order to figure out whether or not, in fact, the transaction is going to result in a diminution of black shareholding.
Thanks, Lebo. Kganki, now, it's accepted, of course, that the Competition Act is part of our country's industrial policy architecture, but arguably it can't be the linchpin to that architecture. And there's also been criticism that really some of the amendments to the Act really were sneaking in industrial policy into merger control through the back door. Would you agree with that criticism? Or do you think that there's criticism justified that perhaps the competition authorities may be straying too far into industrial policy and perhaps even labor policy?
Thank you very much, Xolani. I think some of the criticism is really unfounded, and I think it's because most of the companies or investors they want to do as little as possible. That's why they're always looking for creative ways to actually dodge or not to implement any transformational laws. We've seen it all over the place. They implementing what we call tick boxes. So they will say, if we appoint a black woman as an executive director, we get so many BE points. If we appoint a person living with disabilities, we get so many points. If we bring a black shareholder who's a new entrant, we get so many points. So you can see the intention is not to transform. The intention is to implement as little as possible. And that is the part that is unsustainable. We are talking about what we call inclusive growth. Inclusive growth means in every growth that we need to have as a country, black people need to be at the center of it, not paying lip service, and ticking boxes. We really have to start by implementing the spirit of transformation. The spirit of transformation, if it was implemented correctly, by now we should be at least having Black people owning 50% of the economy, as it should, because this is our country. This is the country of Black people. It has to reflect like it is reflecting anywhere else. If you go to Europe, you are not going to find Blacks owning majority of the economy there, because that's the country of the Europeans, and it has to be like this here. And I'll agree with Shawn. I think maybe because this is the first case under the amended act, maybe the Competition Commission should develop the guidelines. But I think it would be dishonest for any company or any potential investor to say they don't understand or they're confused about the rules of the game. I think that is dishonest at this West. We're 27 years into democracy. People have been here, they've been reading about the country, they've been coming here, we've been having engagements with people. The DTIC has been having engagements with the potential investors, and we've been emphasizing that in any country where you are going, you have to understand the rules. And I think that's why government is here, to get everyone to understand the rules. When you go to China, you understand the rules and you operate within the rules. You don't want to be creative when you get to China. So probably means potential investors may or may not be taking South Africa for granted by trying to implement as little as possible. And that delay tactics is not necessarily progressive. It's not taking us anywhere. It's actually taking us back, because ultimately, whether people like it or not, at the end of the day, Black people will own the majority of the country's economy. Black people will be the majority CEOs in South Africa. It's inevitable. I think you're just delaying it, but it's going to happen. So if people don't necessarily like it, they should, as they say, they should smell the coffee.
Right. Okay. So if I'm hearing Kganki saying, well, you know what, to the extent that there's some criticism that they may be stepping the line into industrial or labor policy, you know, so be it. These are all integrated, and ultimately there's a singular objective that all of these particular policies are all trying to achieve, and so it may be inevitable that there may be some crossover. Right.
Yeah, I think if there are those proposals that let's harmonize all the policies in the country, let's do that. But when we do that, we must not miss the primary objective. The primary objective is to make sure that Black people and people who have been excluded by law to participate in the economy should participate meaningfully. And I think it's important to emphasize meaningfully. You're not going to get meaningful participation by ticking boxes. Right. That is not the spirit of the social economic transformation laws of the country.
Okay. So another question. I mean, so are your members seeing the type of decision that Commission has taken in Burger King as an opportunity? And in particular, I think, you know, if we take one of the questions that have come through from the panel, from the participants, is that, you know, liquidity, of course, is a key factor, right, in M&A transactions. And competition doesn't only occur in the market in which the merging parties are active, but also in the upstream market where investment and investment decisions are taking place. And so, you know, is there sufficient liquidity, in your sense, that would allow more HDI shareholders to acquire all of the shareholding if we were to take the position that it must be on a like-to-like basis or improve what was there before, even if it's not even if there wasn't any HDI shareholding in a target, for instance, but now we're talking about promote. And so you need to increase HDI shareholding that was there. So are your members seeing an opportunity there? And is there liquidity to allow that to happen?
Yeah, I think just to emphasize, the like for like should be a minimum. We shouldn't be going down, we should actually be improving. But I think if there's a problem of liquidity, it's important. It's always important that you must solve the right problem. If the problem is liquidity, let's solve the liquidity problem. Let's not regress economic transformation because we say there's liquidity. If there's a liquidity problem, we've identified that as a challenge. Let's speak to the PICs of this world and other BRICS Bank and others to improve the liquidity. Instead of then say no, because there's liquidity, then we must disadvantage black people. It can't be. I think let's identify the right problem and then solve it with the right instruments, rather than solving it with the wrong instruments that will one day make us to regret as a country.
Right. Shawn, let's bring you into the conversation. So any other thoughts in terms of how the business community and our regulators really can work together to realize what I think are really worthwhile objectives that the Act in its preamble sets out as trying to achieve?
Sure, I think that there's plenty of opportunities from regulators from different countries to talk about these issues. As I said, we're having a debate in the US about what you focus on and how many stakeholders. And so I think there's plenty of room for regulators to get together. I also think that there's plenty of room for, say, academics from South Africa and the United States to be talking about these issues.
Super. So, and perhaps this question to both Kganki and Lebo. Are there certain decisions that regulators should rather leave business to make and interfere as little as possible with those decisions?
Yeah, that's an interesting question. I mean, I heard you say regulators, so it's not just the commission, I suppose, right? Which is even more, I mean, difficult. I think that maybe as another way of assisting the business community, international or otherwise, it should really become it should be made clearer which regulators are looking after which issues and to what extent. And if there is issues where there's concurrent jurisdiction in terms of the different regulators, then again, it should be clarified in advance how that's going to be dealt with. So I guess the short answer is no. I don't think it's correct to say that all decisions must be made by business. I don't think that happens in any jurisdiction. So I don't see why that should happen in South Africa. That said, I do think that in order for regulators and government to assist business to cooperate and in order for government to achieve its objectives using legislation and the different regulators, then the rules of the game must be made clear. And so, it does cause a little bit of anxiety. And I'll use the Burger King example again. It does cause a bit of anxiety where you think that the topic has been dealt with a bit of clarity or sufficient clarity in the case law from the tribunal, and then suddenly you get a decision from the commission in an intermediate merger that suggests that there is actually absolutely no precedent on the issue. And I know that the commission has suggested that some of the case law from the tribunal, which we believe is applicable or could have been applicable in Burger King, the commission has said something like that case law has been superseded by the amendments. But if you look at the case law, in my mind, that cannot be correct, because the theme is the same. The question has always been where you have, where the regulator is faced with a potential dilution of black shareholding, which would, result in an adverse impact on the spread of ownership by HDIs. How do you respond? So I think there's a lot to think about here. And I think the commission has actually done a lot of thinking. Otherwise, we wouldn't be seeing the turnaround in the tribunal. I mean, I was listening to Kganki saying that black business supports the commission's approach, but the question is that the commission now still supports its own approach, and to what extent. You see, it does look to me like there has been a shift, and maybe the shift is indeed because the remedies were offered a little bit too late. I'm not sure. I wasn't personally involved in the Burger King transaction, but it does look as though there is some effort by the commission to undo its decision in Burger King and potentially reflect what we've already seen coming from the tribunal. So I guess, the short answer, Xolani, is that no, no country should ever be asked to allow business to make its own decisions without any form of regulation. That should never be expected of this country either. But in regulating business, I think it's a joint effort by government, by the regulators, policymakers, as well as business. And we can at least try and find a way to set clearer rules which can be followed by everybody.
Right. Kganki?
Yeah, thanks. I think we should be fact-based in whatever we're trying to address, and unfortunately, we also need to learn from history. And fortunately, in South Africa, we've had 27 years of negotiated settlement, type of democracy. So it's important to maybe I'll give you a few examples in answering your question. So let's start with one example. In my village, in Makurung in Limpopo, if I want to download a document, like if I was there now wanting to have this session, I will have to climb a mountain so that I can have a better signal. And that is the failure of a regulator and the failure of the market. So we cannot leave everything to the market. The market has failed in the last 27 years. We have laws, for example, for the BE Act that says ownership of the economy should be 25% or more. Companies have not even achieved 5%. We've got the employment equity report that comes every year. And it indicates that 70% of the CEOs are still white males. So you see, even in spite of laws being there, the market or the companies are still ignoring the laws. Imagine if there was nothing, we just left everything to the market, and the market will decide. If we leave that, probably even the little signal that we have in my village wouldn't be there. I'll have to travel maybe when I'm home. If I want to download a 1 meg document, I'll have to travel 100 kilometers. And chances are the Employment Equity Act, blacks maybe will still be using a different toilets than white people, like it happened in the past, if there were no laws and regulators. So we cannot leave it, and it doesn't happen anywhere in the world. So I support the fact that we should have regulators, but we must also strengthen them. We must give them more teeth to be able to bite if we want to see any progress in anything in all the sectors. We still have all the sectors of the economy being, beside the fact that we've got a competition commission, all the economic sectors are 80 to 90% owned by 3 or 4 companies, which all this is unsustainable. So imagine if there was no competition act, probably the small businesses will not have a space. They don't have sufficient space as we speak, but they will have zero space. The other procurement and other elements in the BEE codes will not have been implemented. So we really need to give the regulators, we need to strengthen them first, and then we need to give them teeth so that they can bite.
So I mean, that I think raises another question, which you brought up, and which was, we need to correctly identify what the issues are and deal with those issues rather than extrapolating. And suppose the question that has come through from our audience is whether is abuse of dominance and exclusionary conduct not the real reason for the prevailing skewed ownership and the lack of ability for SMEs and HE-owned firms to really thrive, to enter and thrive in the market. Because if we're dealing with just mergers and just changing shareholding when it exits, that's not, you're not creating a larger pool of black entrants, as it were. You're just moving decks around. But if we want a thriving economy, which is what I'm hearing is the real concern, should we not be looking more at this dominance, exclusionary conduct, and the like?
Yeah. You again, it's important to always identify the right challenge that we are trying to face. So the mergers and acquisitions is a separate issue. But if you look at what we are trying to deal with now, is that we do have a base, low as it is, that indicates that this is what black people are owning. I'm talking totally as in South Africa. So let's say that base is 2%, and a Burger King type of environment happens. It takes that base to 1.8%. So we are not solving the problem. At the minimum, let's keep that base at 2%. But ideally, let's increase that base to more. That's the one side. The second side, which I agree with you, is that also let's then put a lot of emphasis and focus on the market concentration, the structure of our economy that is highly concentrated. We need to reduce that. We're not saying do away or kill big companies. We're saying the big companies must coexist with small companies, but a sufficient space should be provided for small companies to be able to participate. So part of the economic transformation is that those companies, when the mergers happens, they must still give a black people other opportunities. Black people, women, people living with disabilities, young people, they need still to be given other opportunities in the value chain, procurement, employment equity, training, and so on. So that we keep on increasing the baseline, so that ultimately everything else, economic ownership, management control, procurement, everything else must be reflective of the demographics of the country at some stage. That is the bigger objective, and everything else that we do should be targeting that objective rather than trying to reduce our attainment of that. We should try and improve it at all times. Thanks, Gwen.
Thanks, Kganki. Lebo, do you have a particular view on this question?
Yeah, thanks, Xolani. So I think from a competition policy perspective, we need to remember that competition policy is not the only tool that can address all South Africa's problems. And I think that's the mistake that we tend to make. So we tend to forget that, even if certain provisions of the Competition Act, and even if they're well enforced by the competition regulators, you would still need the entire machine to work properly. You'd have to look at issues of liquidity, as you say, funding. How does the entire structure work together in order to achieve a certain outcome? I mean, if you look at the competition authorities, generally the abuse of dominance in provisions have been well enforced by the competition authorities. Where there have been difficulties, those difficulties have been identified, and in fact, the amendments have made provision for dealing with those challenges. But it must be understood that not all barriers to enter a particular market are as a direct result of abuse of dominance. Yes, I accept that there may be an element that the abuse of dominance by an incumbent may very well be making it difficult for new entrants to break into that market. But certainly it isn't that every single case of abuse of dominance is the sole and main reason that we're not seeing upcoming black entrants in markets. Also, what needs to be considered is the fact that just because there's abuse of dominance in a market, it doesn't mean that the outcome is mainly felt by what would be a black entrant or a new entrant, but it's usually also the outcomes of that abuse are felt by the customers. But that said, I think that where abuse of dominance is dealt with, right, through the provisions of the Competition Act, you would then expect that there would be a new black entrant or an entrant, whatever race for that matter, that would come in. But isn't the other equally important question whether there would be capital? And isn't the other important question whether there could potentially be other regulatory barriers that a new entrant would have to contend with coming into that market? And I think, whenever there's a conversation around competition policy, I think we sort of forget this part, that competition policy is not the end all and be all of transformation in this country and of, making sure that the markets work as best as they can. And in reality, what I think we're going to have see in the near future is a world where competition policy is looking rather ineffective, purely because everybody sort of expects all the problems to be solved by this piece of legislation. But if you look at the wins and the losses of the Competition Commission over the past few years, you can already tell that there is some sort of signaling that there are problems that you will be able to address focusing or using the competition policy as a tool, and others you probably will not be able to. And therefore, what is the answer? What should we be looking at beyond competition policy?
Right. Thank you, Lebo, about that. I mean, I suppose the one question that I would like to test out again, both with you and Kganki, is now in the Act, at least on the competition side, there's what is called the failing firm defense, right? Which can save an otherwise anti-competitive merger. Should that defense, as it were, also be applicable on public interest? So you have a firm, let's work on the same basis, 68% or more shareholding, black shareholding, but really not doing well. Those assets are about to exit the market. It could be a fire sale, but comes along a completely non-HDI owned firm that believes that it can turn around this business, but it wants full control in order to do so. If it's not going to put money in a failing business if it cannot have full control of it. And it is quite clear on that. And financially, it makes all sense. Do you think that perhaps that's something we should start considering and really tweaking that failing firm defense to also apply in that particular case?
Yeah, I think that's another challenge, right? That in fact most of us haven't even thought of. If you think about it, because we're still grappling with the non-failing firm, that's the black shareholders exiting. But I'll answer you with reference to my experience at least. So when you look at the case law again, which talks to a failing firm, because for me that's always the starting point, right? I'm a lawyer. And Kganki will probably have a different view, but I've got nothing else to rely on but what we've seen from the courts. If you look at a case that came from the Competition Appeals Court, I think that was the Pioneer Pana case, where there was issues around the failing firm defense. The Competition Appeals Court said something very interesting in that case. It said, when the authorities are looking at prohibiting an anti-competitive merger on where a failing firm or flailing firm defense is raised, right? The competition authorities ought to be very careful, because it's ideological to simply say, okay, this is a bad merger, we're going to prohibit it. But what the Competition Appeals Court said there is that you should also reconcile yourself with the fact that if you prohibit a merger like that, then you're going to have the exact same outcome, which is that there's going to be exit, right? The target firm will liquidate because they are distressed. So in a way, the Competition Appeals Court was saying, to the lower competition authorities, do not be as ideological when you're dealing with these circumstances, because you will end up with the same scenario of exit. And so you need to choose between the lesser evil, whether you're going to approve a transaction which may otherwise be seen as anti-competitive, but nonetheless save employment, save the infrastructure, keep those assets in the market, or you're going to let them liquidate and lose everything. So I think within that background, then you would want to think about what this means for the exiting of black shareholders, right? And it's actually quite closely related to what I said earlier about Burger King, because if you want to prohibit a transaction like this, where the seller is a black shareholder, what you're basically doing, in my view, would be to make the world a worse off place for the black shareholder, because you're saying, in as much as the black shareholder has not been able to build that company up to a point where the company is profit making, you're not going to allow them the second chance to actually, break out of that investment and go into the next one where they could potentially recover financially and potentially grow in a different market. So the reality is, and again, this is just my personal view, I don't think that this assessment should be extended to where the failing firm defense is applicable. But in the event that it is, I do think that the regulators would have to be a lot more flexible, because it could very well be that the acquirer says, well, it's a take it or leave it situation. At the most, what I will do is give a black shareholder 10% because I want to control this entity. But again, there's a tension between that kind of approach with what Kganki is saying about the fact that we should not have the minimum requirement, but we should be looking at a ramp up of black shareholding in these markets and in these entities.
Thanks, Lebo. Kganki, over to you.
Yes, thanks. I think maybe before I come to address this, I need to talk about the competition legislation. We agree that it's not a solution to all the problems, but because they are doing their job very well, we should actually encourage them to do more rather than criticize them and condemn them. And I think if that happens, the others who are supposed to be doing a equally good job or even better will then be encouraged to join the moving train of the competition commission and do more and do good. And if that happens, and on aggregate, if everyone else in the ecosystem does well, the country would do well. Hence, we were encouraging them and supporting the competition commission because they are doing a good job. And you see they're doing a good job because they can tackle any company of any size. Their justice system, so to say, does not have eyes. So they don't choose that. No, that one is very small. That one is too big. They tackle everyone. So we're encouraging everyone else in the ecosystem to do the same. The second thing, I think we need to be very careful that we don't get misinterpreted. I think that is important, that whatever we say, we don't create an impression that failure is associated with blacks. That it's only a white man who can come and rescue a black a failing company. So I think it's important that we don't create that perception. There are so many companies that are failing every day, owned by all races. So we should not say if a firm is 51% owned by black, automatically it's going to fail. That I think is what Steve Biko spoke about, that we need to deal with very, very decisively. Any firm can fail, owned by any race, owned by any gender. So we should not bring those type of excuses in saying you can only rescue a company when you are 100% white owned. They can still have 49% black ownership, and they can still have control. And then also there are companies where I think as lawyers will know, but there are companies where you are 8% shareholder, but you've got the full control. It depends on the shareholders' agreement and anything else. So we should not encourage those consultants, usually call them innovative solutions, that are trying to circumvent the spirit of economic transformation by always labeling black people as incompetent. That is not true.
Okay. So what I'm hearing is that, you know, even in a failing ailing firm context, you know, the principle of maintain or improve should remain.
Yes, definitely, because again, as I indicated, we need to be guided by the bigger objective. The bigger objective is to democratize the ownership, the management control, the procurement of the economy, so that it reflects the demographics of the country, like it does everywhere else. You go to China, you go to the US, you go to Europe, you go anywhere else, you go to Russia, the ownership and the control of the economy is reflective of the demographics, just like the political system is. So we cannot only have political power, we also need economic power. And that should be the bigger objective on anything and everything that we do.
Thank you, Kganki. Okay, so we are coming to the end of our session. It's been absolutely fantastic. I'm going to ask each person to just share their parting remarks. And just for Lebo, in your parting remarks, if you can just also indicate what you think are the key issues that the tribunal and the appeal court may still need to pronounce on to assist us navigate this journey that we started in 2019 when the Amendment Act came into operation. So whilst you start thinking about that, I think I'll bring in Shawn first and followed then by Kganki, and then you can close on.
No, I mean, looking at it from the perspective of an outsider who wants to invest in South Africa, I'd say that, you know, there is still a need for transparency, and we've gone through a lot of issues that have been raised by the Burger King decision. We've talked about waiting. We've talked about how the Burger King decision may have overlap with other areas like Triple B. And I think that once again, there's a need for as much transparency as possible and as much clarity as possible. And so I would, as I said, I think that there's a lot of room for the commission to use its website to provide guidance. And I think that that's necessary going forward because, as we've all noted before, there's been a lot of controversy generated by the Burger King decision. We're still trying to figure out, for example, if one pillar of the public interest criteria has overwhelming weight. If that's the case, then the commission needs to say that clearly. And so, I mean, as I said before, I think there's a list of questions that either by publishing decisions or offering guidance on their website, they can promote investment in South Africa, which I think is good for everyone.
Super. Thanks, Shawn. Kganki?
Yes, first, thank you very much for the invitation. We always raise issues subtly, and this is what we think will bring solutions to the issues in the country. We should not shy away from raising any issue, and we should not raise it in trying to camouflage anything. We should be straight to the point, and and hopefully we will have similar engagements in the future, so that we can move the country forward. The amendments that happened in 2019 are very progressive, and in our view, so we will encourage people, if they are not necessarily happy with some of them, instead of blaming and wanting to delay the transformation process, let's bring solutions and proposals, so that we can only improve instead of regressing. So the delaying of the economic transformation is not helpful to anyone, because ultimately it will happen. If it doesn't happen in this generation, it will happen in the next generation. It's unavoidable. It will ultimately happen. So let's instead of delaying it, let's accelerate it, so that it happens much quicker, and we can go back to normal, where there may not even be a need for Employment Equity Act. There may not be a need for BEE legislation, because everything will be done on an equity basis. Thank you very much for the invitation.
Thank you, Kganki. Lebo, over to you.
Yes, thanks, Xolani. So, I mean, the key issues, one of them Shawn touched on. I do think that there ought to be clarification by the competition authorities, the higher courts, I suppose, the CAC or the tribunal, on what weight must be given or placed per public interest pillar. I think that would be helpful in assisting us as attorneys to advise the clients, and also for business to understand what's expected from them. But also, I think the other guidance that we need is whether indeed the Competition Act can and should be interpreted by the authorities to say that, you know, the authorities can demand that a transaction promote the ownership of historically disadvantaged individuals. That is in a case where there is no dilution of Black shareholding, for instance. Can the Commission or the competition authorities seek to impose conditions which require the parties to involve Black shareholders in their deal where there wasn't, where the sellers were not Black in the first place? And this, I emphasize, would be applicable in a scenario where, even if it's a failing firm, but the failing firm sellers, the target is actually not Black, but a white firm. So the question would be, you know, and just to make sure that we don't walk away with having created the wrong impression, that even when you've got a failing firm that is led by white people or non-Black people, and presumably the acquirer being white, okay, or non-Black, presumably then would the Commission or the competition authorities have the ability to force the incoming non-Black shareholders to involve Black shareholders in the rescue of that distressed firm? Yeah, thank you, Xolani.
Thanks, Lebo. Thank you so much to the panelists. We are ending off just on time. Just to remind everyone that this recording will be available on our website later today, and that is at www.bowmanslaw.com. And then just to mention that, of course, the Burger King case is before the Competition Tribunal. A hearing occurred on the 18th of August, and we are all awaiting the decision of the tribunal, although that decision may well be limited somehow in circumstances where it went before the tribunal, not on a contested basis, but there was already agreement between the DTIC, the commission, and the parties, and SACTU intervened on more narrow grounds. And so we all await the decision, but probably we'll have to wait for a more pointed and more contentious case to go before the tribunal, in which the tribunal then could give us more direction. It doesn't seem that it will be this one, but maybe the next one. Thank you so much for sharing this morning with us and giving us 90 minutes of your time. Really appreciate it. Have a wonderful day further.